Welcome to this week's episode of Ask an Atheist. $700 million, that's what we're going to be talking about today. The U.S. government gives away $700 million, basically every single year, to, quote, ministers of the gospel. And the Freedom from Religion Foundation is challenging this in federal court. And today, that court heard oral arguments in that case. And we have our attorney, Patrick Elliott, down in Chicago, who witnessed the oral argument, and along with him is FFRF co-president Dan Barker. So just real quick to lay out the case for people, every year you have to pay income tax, no matter who you are, but certain things don't count as income. So for instance, if you get student loans, that doesn't count under your income tax. The federal government allows any, quote, minister of the gospel to exclude from their income any payment that was designated as housing by their church. So the church says $1,000 of your monthly salary is designated for housing, and that actually isn't even included in their income. And the estimates are that that amounts to about $700 billion of lost revenue for the federal government every single year. This was passed in the 1950s during the Red Scare. It was passed to fight against the godless and anti-religious worldview, according to one of the sponsors, Peter Mack. And FFRF has challenged it a number of times, and this time we're in front of the Seventh Circuit here. So Patrick, give us an idea of how the oral arguments went.
Yeah, well, we were represented today by both Rich Bolton, our litigation attorney, as well as Adam Chodorow, who's a tax professor. So we had two experts making our case before a three-judge panel of the Court of Appeals. They certainly, asked pointed questions, and I think got strong answers from our side. The other side is, both the IRS as well as a few congregations of churches who are basically arguing that, that they're entitled to this type of exemption. So I think, in general, we've made our case before the court, and now it's in their hands, in terms of deciding the substantive issues.
So I think the one thing probably that everybody wants to know is what's your prediction based on how the oral argument went? Now, as attorneys, we know that's always a dangerous thing, but did you get a sense of which way the judges might be leaning?
Right. Well, it's hard, and actually only two of the judges asked questions today, so we don't know. Judge Bauer didn't ask any questions. He's traditionally been very good on the Establishment Clause, so we take that into account. It very well, could be a 2-to-1 decision. I think it's hard to predict because it's out of our control. But if there is a ruling that's against us, I imagine it would be very narrow in scope and focus on what courts have grappled with for a long time, which is what type of accommodation of a church is necessary, or what level of entanglement can the government have. Certainly our position is ministers should be taxed just as everybody else is taxed. That's the system that has the least amount of entanglement. The other side is arguing that, in fact, these ministers would have to make claims. If they don't get this exclusion, they have to make claims, and that would involve some incursion into their financials by the IRS. So it's hard to predict. I don't think we can definitively say that FFRF is definitively going to win. We certainly should win, but ultimately we'll just have to see how the judges handle it.
So yeah, the law is on our side for sure. Now, do you have a sense of what sort, if the court does decide in our favor, as they should, what do you think the outcome will be? Will that law apply to everyone? Will that law disappear? What do you think the remedy in this situation would be?
Well, the Judge Crabb, who's the judge who handled this in the district court, has ruled that there's basically the best way to handle it would be to nullify the statute. So really, that decision's somewhat already been decided, and the effect would be over a 10-year period. It's over $9 billion that would be recouped basically that's going untaxed currently, that would be taxed. And so I think the taxpayers would be the ultimate winners. Certainly churches would try to find other means of exempting, or Congress could step in and create a broader exemption that would apply to groups like FFRF and other groups, so that they might be able to get the exemption as well.
So $9 billion that in lost revenue over 10 years. And there's FFRF co-president Dan Barker. Hi, Dan.
Hi, Andrew. We're at a German restaurant. We just had lunch with the attorneys and another law professor.
Well, Dan, I have a question for you on this case too, because FFRF has brought this case a couple of times before in the past. We've tried, and we were kicked out on standing. So how did we get around standing this time? Well, how did we cure the standing problem? I said we weren't injured.
Oral arguments this time were a lot different. Last time, standing was a big issue. And this time, I think you were in the courtroom, weren't you, Andrew?
I was the first time, yes.
Yeah. So, and this time there was no procedural, there was no standing issue at all. It was basically on the merits. And the first time they told Annie, Lori, and me that we didn't have standing to sue because we were not injured. We had not asked for the money and been denied, which was, I think, their way of ducking the issue. Ducking the merits. So it took us 4 more years to go through the process of asking for a refund and finally getting turned down and finally getting actual injury from the IRS itself, a strongly worded letter saying, no, we don't get it. So we're back in court now, having corrected that standing problem, and now we're dealing with the issues. So what did you think, Patrick? Was that?
Yeah, I mean, that summarizes it. That really didn't come up this time around at all, which obviously was the focus last time. So you certainly have Dan and Annie Lori and the estate of and the coal dealer all have standing to challenge it.
So one thing that was a little troubling, Judge Mannion, who has never been a very good friend of ours, was asking questions like, well, don't churches do really good things for the world? And when a pastor is giving marriage counseling, isn't that really a secular benefit to society? Aren't a lot of the things that churches do, aren't they actually good for the secular world? And of course, Rich and Adam did a great job, and Rich did a good job, and they shared the oral arguments. They pretty much knocked that down, and Mannion kind of asked Rich, didn't Mannion ask him, well, what are Dan Barker and Annie Lori Geller, what kind of good things are they doing for the world? So it's a little troubling to get that kind of a question from a judge comparing nonprofits about who's doing a better good or who's doing more secular. And Rich answered that by saying, well, we have our good purposes for the world too. Just because we're atheists doesn't mean we're not also benefiting the world in a good way.
One would hope a federal judge could get behind an organization whose sole purpose is to uphold the First Amendment. You'd think they would get behind that. Some of the churches. Well, some of the churches there that intervened are these local Wisconsin and Chicago churches, and these ministers that are. They have a better story to tell for the other side. But this housing exemption, or the Parsonage Exemption, also is available to the Joel Osteens of the world and these mega preachers with their McMansions, and they're cashing in on the American taxpayers. Did that get mentioned at all?
No, that didn't come up. But Rich wanted to make the point that that's all beside the point. The government shouldn't be asking who's doing the greater benefit or the worse benefit, as if we atheists had to justify ourselves, like, hey, we're doing good works too, we should get this.
But, I mean, to Andrew's point, actually, it did come up, the fact that even if this is really unwise, this is from the government's attorney, even if this is really bad policy, even if this is really a bad law, they still think it's defensible. So it's kind of interesting that the government's attorneys weren't defending the soundness of this, because we know that pastors like Rick Warren take huge housing allowance and exclude it from their income, even though they make much more money than any teacher or firefighter or other public servants would do. We have these very wealthy individuals that are getting the exemption. So it didn't really come up, but it was interesting to hear that the government didn't necessarily defend the soundness of how wise this is as a policy in general.
Now, the two attorneys who argued this are Adam Chaudhary, who is a tax law professor, and Rich Bolton of the Boardman Clark law firm here in Wisconsin. Can you tell us a little bit about how they divided up the argument and who kind of did what?
Yeah, so Chaudhary went first from the tax angle, who's an expert, because he and 22 other tax law professors submitted an amicus brief in our favor, countering the amicus brief sent by the other side by 2 tax law professors. And he went first and did a great job of distinguishing. You know, they were trying to raise convenience of the employer, and he said none of these other supposed blanket convenience of the employer cases or provisions of law have any relevance to what's happening with the churches. So the other side was arguing that, and he pretty much knocked that down. He was very, very strong and very powerful on the tax law. And then Rich Bolton, our attorney in Wisconsin, he came on and then argued more of the establishment clause side of things. They were asking him questions like, well, in which was it? In Texas Monthly, they were which opinion prevails in Texas Monthly? He was asking.
And that course, of course, is about, whether a special, Texas statute exempting religious publications from sales tax was permissible. And the U.S. Supreme Court struck that down. And so we certainly think that's a case in our favor. Special exemptions on taxes have already been ruled unconstitutional, and that should be applied here as well.
So, guys, this is Ask an Atheist. Can you stick around and answer some questions that we're getting from viewers?
We might be able to do a few questions.
Okay. Well, I have a good one from Michael Coleman, which goes to the point you were just talking about, who asks, wouldn't it just be easier to tax the churches?
Yeah, I mean, that's the solution. That's really the ultimate solution that we're asking for.
Tax churches or tax the ministers? The
minister's income. Yeah. But overall, that's a different issue that Congress would certainly have to decide, and it makes a lot of sense.
And Chodorow brought out the point that it's not entanglement for a minister to pay full taxes on his full income. There's no entanglement issue at all. We all have to do that. When you have your income, you can have your deductions, but to exclude your housing, that would not be an entanglement at all. It would just be that an employee of a church, which is a pastor, would be paying full taxes.
And that's an excellent point, because one of the main purposes of the First Amendment is to prevent the entanglement of the government and religion. So that's one of the things that the court's going to be looking at, and pointing out that, hey, these aren't actually churches. This is just an exemption that happens to be for the ministers in their individual personal capacity is a big distinction to be made.
Yeah, and the other side made a big deal out of entanglement. They thought entanglement would be worse if we won.
Now, is this exemption, asks Brian, only available for Christian ministers?
No, I mean, it has been construed to also apply to, excuse me, it has also been construed to apply to rabbis and other religions, even though on its face it doesn't say that.
It says ministers, quote, ministers of the gospel, correct?
Yeah, that's
right.
What it says.
On its face, it was intended, obviously, to apply to churches. It's been broadened, even, in more recent years, to apply to things like basketball ministers, basically any employees of religious universities such as Pepperdine. So it's really been opened wide up in such a way that actually, there's more abuses of it given the amount of people who are benefiting.
I think even
and by the way, Andrew, it's not really an exemption, it's an exclusion. It's not even reported.
Exactly.
It's just not even. Yeah.
Yeah, and I think choir leaders once got the exclusion too. I seem to recall. It has been kind of ripped open a lot. Now, did the history of the law get touched on at all? Where did this law come from?
It did, and actually Professor Chodorow addressed that with basically pointing out that it only came into effect in the 1950s. Really. When there was a special exemption adopted. We didn't even have income tax until the early 1900s, so it doesn't even go back as far as the founding of the country.
Excellent. All right, guys. Well,
at the founding, since there was no income tax at the founding, the law relating to churches had to do with property rather than with income. And this housing allowance is an exclusion from income, which is a totally different issue.
Well stated. All right. Well, we'll let you guys go since there are now people eating behind you. Thank you very much for Skyping in from Chicago, from the 7th Circuit. So that was, straight from the horse's mouth pretty much here. They actually don't allow us to have cameras in the federal courthouses, believe it or not. So that's going to pretty much do it for this episode of Ask an Atheist. I don't see any further questions, but that was exciting. FFRF has actually had three 3 oral arguments in the last 2 weeks. We had an oral argument in our Dan Barker versus the House chaplain case last week. That was in D.C. And then we actually have one on our West Virginia case coming up early next week. So 3 oral arguments in 3 cases in the last 2 weeks. If you want to be made aware of big things that are happening that you can do to help FFRF, please text 52886. FFRF to 52886, excuse me. Text FFRF to 52886, and you'll get alerts right on your cell phone when, for instance, Donald Trump appoints a Supreme Court nominee, which hopefully that won't happen again. And also, please, go vote. You can early vote now in most places, most precincts. Get out there and vote. It is the most important thing that you can do as a citizen. And then text FFRF to 52886. And after that, join us next week for another episode of FFRF's Ask an Atheist.